right, good morning, everyone. We're going to go ahead and get started. I'm Megan O'Brien, the Assistant Director at the Family Business Center. And this morning we have Eastman and Smith here to talk about non-compete, non-solicitation, and non-disclosure agreements. Thank you to all of our sponsors, Eastman and Smith, Shoemaker, Raymond, William Bond, Fifth Third, Pilot, Skylight Financial Group, Huntington, and Family Enterprise USA. Jared is a business litigator and Ann is an employment attorney. So I'm going to turn it over to them and let them get started.
Thank you. Good morning. As you said, I'm Jared Lefevre. I'm a member of the litigation section of Eastman and Smith, where my practice is mostly business and commercial litigation, including enforcement and defense of non-competition and trade secret claims.
I'm Ann Schmidlin. I'm a member of the labor and employment section. And as it pertains in particular to this presentation, we help counsel clients with regards to drafting enforceable non-compete agreements, advising when you might be onboarding an employee who's subject to some sort of restrictive covenant and navigating those contours. And with our powers combined, when things turn to litigation, that's why we're here today, is to talk a bit about the current environment that we're in now, the attitude towards non-compete agreements, and what you all can do as business owners and working professionals in the short and the long term in light of that environment.
And Ann is being a little bit modest. She's also the head of our interdisciplinary non-compete practice group, where we have members of our firm across sections meet on a monthly basis to discuss developments in this area. And she's done a great job running that. So she's a real expert in the room.
Pressure. So I hope that whenever a question or a scenario pops into your mind, that you'll feel free to make this an interactive conversation, because I think that'll be a lot more valuable than us talking at you, although we certainly can do that for 60 minutes or more. But please feel free to interrupt us. So before we kind of get into the meat and potatoes of everything, we throw around non-compete, non-solicit, clauses a lot, and I fall into sometimes myself the bad habit of calling everything a non-compete. So-and-so signed a non-compete, or company X is trying to enforce a non-compete, but a non-compete is just one small aspect of the large umbrella term of restrictive covenants. So humor me for a second as we kind of go through and delineate what each of those types of clauses are, and sometimes they're standalone agreements, sometimes they're folded into an employee handbook. The non-compete, of course, itself prohibits employees upon their departure from engaging in certain activities, from working for, it might be a specifically defined group of competitors or a generalized industry within a specified geographic range for a specified period of time. In Ohio in particular, the longest time that you're going to be able to have an enforceable non-compete agreement is at most 24 months or 2 years. Oftentimes that'll be also highly fact dependent on, okay, you have a 24-month non-competition agreement. What's the geographic radius in which you're prohibiting that competitive activity? Is it 10 miles? Is it 15 miles? Is it nationwide? Because the courts, when we're looking at enforceability, a court's going to look at all of those different factors. The longer that you have that restrictive covenant, that non-compete in place, the more narrowly tailored and reasonable the definition of what's going to be deemed competitive activity needs to be. Also, the non-solicitation clauses, which are very common, both of non-solicit customers, so an anti-poaching agreement, that employees upon their departure are not going to go after this specified group of customers, whether it's current customers, warm prospective customers that employee might have been working with or building a relationship for, again, for a specified period of time. And similar to its sister, the non-compete, again, the outward longest period of reasonable enforcement is going to be 2 years or 24 months. And then, of course, the non-solicit of employees. You can prohibit a departing employee from, poaching your other talent and, perhaps setting up shop, creating a competitive business down the road and trying to take his or her buddies along for the ride with them. And so that's where the non-solicit of employees comes in handy. Confidentiality clauses we'll spend a lot of time talking about today. In particular, in light of the crackdown and potential crackdown we're seeing on the scope of enforceable non-compete agreements, now is a great time to be either putting into place a confidentiality clause or examining what is in your confidentiality clause, because unlike the non-compete and non-solicit, which are only enforceable for a specified period of time, your confidentiality clauses can be indefinite. And so you want to be purposeful in how you're defining what is confidential, proprietary, and potentially even under Ohio law, trade secret information, so that you're putting your employees or a specific group of employees who are privy to that information on notice about what the company is deeming confidential. Intellectual property, Jared and I are not intellectual property attorneys, but I know enough to be dangerous and speak on it a little bit. If you are in the business or you have a group of employees that are creating a product, services, graphic design for you, having an intellectual property clause in place that clarifies that anything that that employee creates or generates during the course of his employment with you, or using company materials to create that product, will be the intellectual property of the company. And then finally, non-disparagement clauses. That was a laser pointer.
I'm trying to be
helpful.
I found it. I was very excited to do it. So.
The non-disparagement clauses, again, you typically see these when you're perhaps negotiating an exit for an employee that might not be leaving on the most favorable terms, and you want to make sure that the parties are mutually not disparaging each other. And so that's one way to restrict the type of communications that are taking place.
Okay, so we'll talk most of the presentation.
I'm sorry.
To the extent you can, as you go through this, can you comment if there are any differences between employees and contractors, folks that are compensated from a 1099 standpoint?
Sure.
I assume in some cases there would be differences.
Right. Yeah. So generally speaking, an independent contractor is not going to be subject to a non-compete clause, because the point of an independent contractor is that that person works for himself or herself, and so is providing that service to a wide variety of clients. However, there can be reasonably tailored non-solicit clauses, and certainly confidentiality clauses if that independent contractor is going to be privy to confidential information regarding your business, that they can be required to sign off on those types of obligations.
So you can or cannot include in the state of Ohio non-compete, non-solicitation for a 1099 contract.
I think it depends on the circumstance. I mean, as we'll get into, non-compete enforcement turns on the reasonableness of the restriction and whether the employer or in this case, the principal who's engaging a contractor has a legitimate business interest to protect. And so it's going to depend on the relationship between the parties and what exactly is being restrained and for how long and to what extent. As Ann's saying, in a typical context, the independent contractors working for a variety of people, not just you. So definitionally, if you're locking that person into only working for you, you might be running into a problem of they're no longer a contractor, but your employee. So it may depend on the context and what exactly you're trying to restrain. And we'll get into that, I think, as we go along. That helps answer the question. So the state of play in terms of where we are right now in non-compete interpretation and enforcement in the court system. This is a kind of a map of how things work in the United States. Right now, enforcement's dictated at the state level, depends on state law. The majority rule, as I just said, is reasonableness. Most states are going to look at these clauses to determine whether it's reasonable and whether it protects legitimate business interest of the employer. And if it's reasonable, it's enforceable. Now, what that means is going to be very fact intensive, depending on context. So it seems like a simple rule, but it's not. But in general, in Ohio and Michigan, which is what I assume concerns most of you, if you've got a reasonable restriction, it will be enforceable. And in Ohio specifically, courts have the authority to revise your agreements to make them reasonable to the extent they're unreasonable, and to allow enforcement, even if there's some aspects of it the court might deem unreasonable. Other states are much more strict. You'll see the ones in yellow are states where depending on the wage level or the salary of the employee, you cannot have a non-compete. Like Illinois, for example, if the employee makes less than $75,000 a year, I believe, you cannot lock them into a non-compete. And in California, they're basically illegal. California is probably the most restrictive state, unless it's in connection with the sale of a business, is really the only exception. You cannot put an employee in a non-compete. So to the extent your business has operations outside of the state of Ohio, it's important for you to look at that state law there, or have a lawyer do that for you, obviously, and give you advice as to whether the non-compete that you may have in Ohio that's reasonable and enforceable, whether that's going to work in Oklahoma or Nevada or these other states where you see variations in color.
So as I'm sure you all have seen in the news with the FTC's proposed rule, we're looking at potentially the virtual ban of the use of non-compete agreements entirely. And so, you know, kind of to set the stage a little bit about how did we get here? Certainly the restrictions on non-competes are not anything new. It's something that we've seen occur over the past decade or so. You know, as Jared mentioned, right now, what's considered enforceable in any given state is a state-by-state analysis. And different states have taken different approaches. So for example, some states use a wage threshold. You know, we don't think that a non-compete would be fair or enforceable for some of our lower wage earners. And so we're going to say you cannot require an employee to sign a non-compete agreement if they make below X amount. And as an example, Illinois, Colorado's got a much higher wage threshold. I think it's $112,500. Anyone who makes below that is a non-compete would be unenforceable. Other states have taken the slant that they're going to ban non-competes entirely, as we saw just a handful. Still other states, New Jersey right now has a proposed rule that would require if in fact you made your employee sign a non-compete agreement, that while that employee is sitting on the sidelines following his or her separation from your organization, that you would have to pay not only that person's salary, but also their benefits. So that would really make you think about what exactly you need to protect and how vigorously you need to protect it if you have to pay somebody to sit on the sidelines for whatever that restrictive period might be. The Biden administration back in July of 2021 issued an executive order that was called Promoting Competition in the American Economy. And that executive order itself didn't impose any specific requirements or rules, but there was a fact sheet attached to that executive order in which the White House called upon the FTC to consider enacting rules that would ban or severely restrict and limit the use of non-competition agreements, non-competition clauses. So it's no surprise, flash forward to you know, a little over a year later, we're now seeing that the FTC has come out with this proposed rule that's doing exactly what the executive order had somewhat signaled. And we're also certainly seeing the Workforce Mobility Act that was recently introduced, thanks Jared, that has failed a few different times. The Workforce Mobility Act might sound familiar to any of you. It was first introduced to Congress in 2018, again in 2019, and then again in 2021. Each time it didn't get enough to get off the floor, it didn't even get to a committee vote, it stalled out. What's different about the climate now is that it's coming on the heels of the FTC's proposed rule. It's been reintroduced by a bipartisan group, and it largely mirrors a lot of the definitions of what's considered a non-compete restriction that the FTC proposed rule does. But it goes a little bit of a step further because it provides for a private, it would, if it were enacted, provide employees with a private right of action. The FTC proposed rule is, you know, the FTC only has the ability to enforce the proposed rule. If the Workforce Mobility Act were to come into play, that would allow an employee who alleges, hey, I've been subjected to this non-compete agreement. I would like to myself personally sue my former employer to recover potentially actual damages and attorney's fees. The Workforce Mobility Act, again, it's something that we're just keeping an eye on and monitoring. Like I said, fourth time's a charm perhaps with the sort of the turn of the tides in the FTC proposed rule, but I think it's a little bit too early to make projections about how seriously we should be taking the Workforce Mobility Act. It's something to keep on our radars though, certainly. It is silent on whether or not non-solicitation clauses are enforceable. And as Jared will get into, the FTC proposed rule, much like the Workforce Mobility Act, there are two different definitions of what's considered a non-compete. The act defines the non-compete itself, as well as what's a de facto non-compete. In other words, maybe it doesn't have the label of a non-compete restriction, but it certainly is walking, talking, and acting a lot like a non-compete restriction. The only exception to the ban on non-competes for the Workforce Mobility Act would be via the sale of a business. And even then, that restriction could be no longer than 1 year. Typically right now in Ohio, and I believe also Michigan, during the sale of a business, if the parties exchange on, restrictions, you can have a non-compete agreement for far longer than the traditional 2-year restricted period, it could be 3, 4, maybe even 5 years. But that would be inhibited, again, were the Workforce Mobility Act to move forward. So kick back to you, Jared.
All right, so the FTC proposed rule, which you've probably heard about in the news, was announced in January of this year. And the background on that is, as Ann said, not only did the Biden administration direct agencies to look at non-competition agreements, but this has been brewing for a long time, going back to the Obama administration, where in the wake of the Great Recession, we had persistently low wage growth. And the government was looking at what regulatory changes they could potentially make that would encourage wages to rise in growth and employment. And there was a growing argument, and it was a bipartisan argument in some circumstances, that non-competition agreements might be one of the causes for the low wage growth in the economy. Obviously, things have changed in the last couple of years, but if you'll recall, we had about a 10-year period where wages were kind of just stuck. And the argument was that non-competition agreements had become so pervasive and prevalent industry-wide that they were having their intended effect, right? They were preventing competition between employers for employees. And if you as an employer didn't have to be concerned about your employee jumping ship to your competitor, you didn't have to pay them as much as you might otherwise. And the employee who felt locked into their job didn't feel that they had the bargaining power to go to their boss and say, I want a raise because I'm worth more than what you're paying me. And they also didn't have the leverage to go say, I'm going to go work for your direct competitor and I'm going to do the great job I'm doing for you for him. And we're going to beat you. And so you got to pay me more. And so the argument was, we need to unlock that leverage and that bargaining power by reducing the amount of non-competes in the system. The other argument was that from a job creation perspective, what if you're the best employee in the widget factory and you've got a great idea of how to do the widget differently, and your boss just doesn't want to do it and won't listen to you, and you'd like to go leave and start your own widget factory? Well, if you're locked into a non-compete, you can't do that. And some people would argue, well, why are we preventing that person from going out and creating a new job, innovating, creating a new business that can employ more people and unlock potential in the economy that's getting restrained? So that's kind of the philosophical argument that has been percolating over time. And as you saw on the map earlier, the states that have banned non-competes outright just aren't left-wing or West Coast states. There are some states that we would code conservative or right-wing. So it was an argument on both sides of the political aisle. It wasn't, a left or right thing. So that argument has been percolating for some time, and the different economists have been making that argument and looking at it. Obviously, the other side of the equation is, from the employer perspective, wait a second, I'm investing in these people. They're making the wages they make because I've taught them how to do these things. I've given them these skills. I've given them these knowledge they would not have otherwise. And how is it unfair for me to say, don't take what I've, you're not allowed to leave and take what I've imparted to you and compete against me? So that's sort of the philosophical debate in which this regulation arises. But as the FTC announced in January, And the Biden administration has really fallen out in the original argument that or the first argument I laid out, which that if we, reduce the amount of non-competes in the economy, that's going to unlock greater economic potential and higher wages across the board. So that's a philosophical debate. So the big picture, what happened? January 5th, 2023, the FTC announced a proposed rule. What does the proposed rule do? Well, effectively, it bans non-competes nationwide, except for some industries, which I'll talk about, and except in the sale of a business. Unless if you are a 25% or more owner of a business, if you sell those assets or your interest in the business, that's a circumstance in which the FTC says, okay, that's fair for you, since you're selling the goodwill you've accrued in the company, for you to sit on the sidelines for a little bit in terms of a non-compete. But every other employee, you cannot be bound by non-compete. And that's not just on a going forward basis. The FTC rule would ban all non-competes that currently exist. So to the extent you've got non-competes now, or with former employees, if this FTC rule goes into effect, they're void. And not only are they void, but you as the employer will have to send letters to those employees, notices to those employees, letting them know you're no longer bound by your non-compete, it's void and unenforceable, go forth and prosper, effectively is what the FTC says you have to say. And so what do we mean when we say non-compete? I mean, traditionally, when we think about non-compete, we just mean you can't work in this industry for a period of time in this geographic area. The FTC rule is a little bit broader than that. It's effectively anything that's going to restrain the employee from engaging in competitive activity. Whether that's framed in terms of employment or not, the FTC rule would allow it to be considered a non-compete, and that would include non-disclosure or non-solicitation agreements potentially, if they would have the de facto impact of preventing that employee from competing with you. So if you try to skirt the non-compete rule by not having a restrictive covenant not to compete within your employment agreement, but craft such a broad and oppressive confidentiality agreement, non-disclosure agreement, or non-solicitation agreement, that you would effectively rob the employee's ability from getting a new job that would be competitive, the FTC is going to say, nah, that's still a non-compete. It's unenforceable as a matter of law. And why did the FTC do this? Well, like I said, it comes in the background of trying to figure out ways to unleash wage growth. And maybe the Federal Reserve doesn't want them to do that right now. But 2 years ago, when this process started, that was a problem in the economy, and the FTC is looking to fix it. Okay. Did I do this already? I did this one already, didn't I? Okay. All right, so like I said, it's a very expansive definition of non-compete. It's not just the restrictive covenants you presently have, it's any other agreements you have that would make it difficult for the employee to get a new job somewhere else. And it would apply to 99% or more of the workforce. So specifically, the FTC lays out what's called a functional test. And if it's the de facto impact of the agreement functions as a non-compete, it's unenforceable. So there's a little bit of a vagueness in there as to whether non-solicitation agreements with customers would be impacted by this rule. But if your agreement with your customer would prevent the customer from hiring your employees, you may run afoul of the rule as well there. Okay, so there's limited exclusions. Like I said, the sale of a business. Traditionally, as Ann said, if you're the owner of a business and you sell it, courts are much more likely to enforce the non-compete, even for a lengthy period of time. If you've ever sold a business, it's pretty typical to include some kind of restriction to that effect, often with some earn-out payments over time associated with the non-competition clause. Sometimes you're kept on as a consultant to the new entity as consideration to avoid any competition. Those are all circumstances where it seems very reasonable and fair, where you have sufficient bargaining power between the parties for the FTC to say this is reasonable and enforceable. And we don't think that's unduly restraining trade or limiting wage growth. So the FTC has made an exception for that. Importantly, as I said, though, that applies only if you have a 25% or more interest in the business. So if you've got minority partners or shareholders in a closely held company and you sell the company or the assets of that company, those minority shareholders or members, if this FTC rule goes into effect, cannot be bound by a non-competition agreement. So that's going to probably drive down the value of your business and your assets. I'm not an accountant, but I would assume that anyone who's doing a business evaluation, if you've got minority members who have insider knowledge of how you were conducting the business, what your processes were, what your price points were, what your costs were, and they can go compete with you directly or the new business directly, the value of what is being acquired in an asset purchase is going to be diminished, right? Whereas right now, if you're buying a business, a lot of the value is going to be associated to goodwill, right? Attributed to goodwill. And if you've got 24% or less of that goodwill not coming to you in a sale, that's going to drive down your price. There are certain industries that are excluded implicitly, and that's because under Section 5, the FTC does not have regulatory authority over banks, federal credit unions, savings and loan institutions, airlines, and common carriers. Now that sounds like a whole lot, right? Because you're probably saying, Jared and Ann, this is like a huge portion of the economy. Why are you so concerned about this? Well, think for a second, though, about what we talked about with how non-competes are enforced right now. Non-compete enforcement right now is driven at the state level and is determined based on reasonableness. If the federal government issues a regulation saying non-competes in every other industry except these 5 are illegal and unenforceable and void, if I'm a state court judge faced with a non-compete in a bank's circumstance, I'm going to be looking at the bank's lawyer asking, how come it's reasonable for this guy to be locked into a non-compete, but Joe Schmo, who works for an accounting firm, is locked, can't be bound by non-compete? How is that reasonable? Explain to me. Just because the FTC doesn't have regulatory authority, that makes it reasonable? So I think even though these industries will be excluded or implicitly excluded from the FTC's rule, I would think state courts are going to be much more skeptical about the enforcement of non-competes going forward if the federal government announces this as a matter of public policy, that we're not going to enforce these anymore in most of the industries of the country. Okay, so generally speaking, like I said, this rule will not impact current non-solicitation, non-recruit, or confidentiality agreements you have with your employees. However, you're going to have to look at them, and you're going to have a lawyer to take a look at them and advise you as to whether how they're presently drafted really protect just your information or your employee base, or if they are preventing that employee from going somewhere else to work. And the reason test here would be, take a look at it, and if you were that employee and you got fired or you quit, and you presented your contract to a new employer, would that employer hire you? I mean, that's the reason test. Not what you think is fair to you. Ask what would be what a new employee, if that employee was coming to you with that agreement, would you think you could hire them without drawing legal action from their former employer? And if the answer to that question is, I'm almost certainly going to get sued if I hire this guy, then your agreements are probably not enforceable under the FTC's. Okay, so what happens to existing non-competes? Again, they would be rescinded. So as a matter of law, even agreements that were made prior to the FTC's rule, even agreements for which you've already paid consideration, and maybe you specifically negotiated with that employee on their departure to pay them some kind of earn-out or pay them additional monies that you don't believe were owed in order to get them to agree to a non-compete. Too bad, it's unenforceable now as a matter of law under the FTC's rule. Excuse me. So not only that, but the FTC is going to put the onus on employers to make sure that's clear to employees by contacting them formally. There's a draft notice language in the proposed regulation telling you exactly what to say, but you're going to have to go track down who do you have non-competes with, and you're going to have to contact them. You know, and most businesses keep perfect, accurate records, right? Especially the HR department. So you've got that readily available. Probably not, right? It's going to require a massive effort for a lot of employers to track down who have we ever had a non-compete with? Are they still alive? Is it still enforceable? Where do they live now? You may have no idea where some of these people are. And if you don't make the effort to track them down and issue the notice required by the FTC, you may be subject to regulatory enforcement action. So even though this rule is not quite yet in effect yet, and we'll talk about, the likelihood of it of fully being implemented, it's something you should probably start thinking about immediately in terms of if you have non-competition agreements with employees, which employees, who are they, where are they now? And if you have to make these notices published out, are you going to be able to do it when you're required to?
And sorry, just
Go
to
ahead.
be clear, you're also saying past employees.
Yes, that would include past employees. So anyone that was formerly employed by you that is still subject to a non-competition agreement, you have to let them know they're released from it. It's void. It's unenforceable, and you will not be taking any action against them.
But that, we could assume that that's like within the last 2 years, since it would only be enforceable in Ohio in the last 2 years.
Right, if you have a right just on a non-compete. Some of you might have non-competes that say 5 years, 10 years, 15 years. And even though they're probably unenforceable right now under Ohio law, legally, I think under the FTC rule, you would still have an obligation to notify those people. Even though you're probably never going to try to enforce it, you would still have to send them that letter.
If we assume that any payments that are going out, we can stop making as well.
Well, and isn't that an interesting question? Because certainly that would have been one of the bargain for terms. For example, in a severance agreement, you're paying out severance over a period of however many months, or maybe a lump sum payment, in exchange for an agreement that this particular person is not going to compete with your business. And where we have a, federal body saying now that one specific term is no longer enforceable, I'm going to imagine most severance agreements, most agreements generally, separation agreements include a severability clause. And so that would just, sever out the non-compete, and all the other remaining clauses would remain intact and enforceable, theoretically. But I do think that that is an area, and like, as Jared's kind of mentioned, this is really, we've used it so much during the pandemic and beyond, unprecedented, but it really is a unique way in which a proposed rule could potentially be enacted, because we're not just talking about, okay, from the date that the rule becomes effective forward, this is, the law of the land. We're also saying you also have to retroactively go back to self-correct. So I think that is certainly going to be a source of a lot of litigation. My argument right now would be, I don't have a good argument for how you could get out of it, because I think if there is a severability clause in there, which is usually what we counsel clients to do, we might have to think about including a clause like that because of the impact it might have on them.
Yeah, I think Ann's right. Most likely the agreement would include a severability clause, which typically in a contract will state if any clause of the contract is deemed unenforceable at a later date, that doesn't impair the remainder of the contract. So to the extent that this would render the non-compete restriction unenforceable, the employee's argument and their lawyer's argument will be, well, I'm still entitled to the consideration I bargained. The other argument the employee is going to have is impossibility. It's not my fault as the employee that the federal government rendered what you wanted me to do unenforceable and illegal. I can't be restrained from competing anymore, so you can't fault me for that, and I'm still entitled to the consideration I bargained for. So I think Ann's right. Ultimately, you're probably going to be on the hook for the payments. It will be the source of litigation, for sure, though.
Someone's gonna go for callback. So.
Yeah, so if somebody would, and it may be that if you're doing non-competes now, that may be something you want to look at, right? If you're tying the non-compete restriction that you're imposing on your employees to some kind of tail consideration of payments over time, or a severance payment you're making upon the separation of an employee, you might want to build into your agreement some contractual provision to the extent that the non-compete restriction is deemed unenforceable or illegal, as either by a state court or by action of the federal government. The payments you've made can either be clawed back, or if you've got future payments stopped. That's something you given this right now, given the knowledge we all have, that's something you ought to take into account and bargain for in your agreements.
Makes sense why it's bipartisan,
Right. Right.
especially with tech companies right now.
Okay, so how would this proposed rule impact state non-compete laws? Well, as we've discussed, right now it's on a state-by-state basis for most industries. Obviously, the federal government has regulatory authority over the entire country. Supremacy clause means that regulation is going to triumph over the state law. And like I said, my suspicion would be, it's not certain, it's just my suspicion, would be that state courts are going to be more skeptical of non-compete agreements if the public policy of the federal government is that writ large, they're unenforceable in most contexts. I would think that would be a persuasive argument to most state court judges that non-competition agreements in other industries that aren't impacted by the FTC rule are no longer or should no longer be enforceable. And I will say, as Ann said, the trend right now is there is already skepticism within the state court system as non-competes. It used to be you could get non-competes enforced for much longer than 2 years. That window keeps getting shorter and shorter, I think. I think geographic scopes get looked at more skeptically. Do you really need to prohibit somebody from working, 3 hours away from where they presently work? Do you really need to bar somebody from working in an entire state? That sort of thing. So I think is increasing skepticism of non-competition agreements in state courts, particularly for low-wage workers. I mean, if you remember a few years ago, there were cases involving Jimmy John sandwich makers, things like that. Of course, saying, really, what are we doing here, folks? I mean, is that really trade secret? How much mayo you put on the turkey and Swiss sandwich? That sort of thing. So I think that this, while it won't overrule state law in every circumstance, I think the impact would almost certainly be increased skepticism from state courts and reduced enforcement in terms of length, scope, and activities that are prohibited.
Okay.
Now it's answered.
So we are currently in the comment period for the FTC's proposed rule. That was just extended. It was supposed to have ended back in February 21st. And right on the eve of that, they extended it another 30 days. And I think we now have until, April 19th for people to continue to submit comments. Certainly, there's a lot of impassioned feedback, a lot of impassioned comments that the FTC is receiving. In fact, back February 16th, before the original close date for the comment period was the 21st, the FTC hosted an online 2-hour open forum where essentially anyone could join and participate on first come, first served basis and share their feedback. That's now in the process of being transcribed and available for review as part of the public record. I went on just this morning and there are over 9,000 published comments, some of them by name, some of them left anonymously. And I think the interesting observation is in looking at some of those comments, most of the comments that I clicked on, and again, believe it or not, I did not spend this morning going through each of the 9,000 comments, but most of the comments are in favor of the proposed FTC rule. And I think this is the case for a couple of reasons. One, I think generally the run-of-the-mill employee is not thinking about the FTC's proposed rule. It might not be on every person's radar. However, there are certainly a lot of interest groups that have and labor organizations that have an invested interest in pushing forward this FTC's proposed rule. And so, providing some thoughts and guidance to those individuals that are in their interest group to kind of set forth that messaging that, hey, we think that this FTC proposed rule is appropriate because, a lot of the comments actually were from veterinarians and physicians that I saw, that the restrictions that are currently in place, prohibit them from providing services, and that they need to pick up their families and move entirely. And is that really fair for a non-compete to restrict you in that kind of way? Certainly there were some comments from businesses, generally anonymous, because again, these are public records. So you want to make sure any information that a business is sharing is, you're not sharing any of your confidential or proprietary information. And it was making exactly the points that Jared's already reiterated. You know, we are spending time, resources, money, training, and letting, you know, once an employee rises to a certain level or has a certain responsibility within our organization, we're giving them a peek behind the curtain of, you know, what's our marketing strategy, what's our sales forecast, who are our top customers, who are the prospects that we're going after, and to engage in that level of trust with a specific group of employees and spend the time and resources to train those individuals and have them be able to just take that information and walk down the street and go share that with the people that we're competing against is intrinsically unfair. And that was, you know, going back to philosophically, you know, getting a little philosophical, that is the true point of a non-compete agreement. It's not to eliminate all competition, but rather to eliminate only that competition which is unfair. So we're in the comment period now. Certainly we've seen a lot of pushback from FTC Commissioner Christine Wilson. She thought that we needed to extend the comment period to at least 60 days rather than 30 days. And when the FTC first issued its proposed rule, she issued a concurring statement that was a strong dissent that this is, you know, a major deviation from hundreds of years of precedent and well-established case law on, you know, the enforcement of these kinds of agreements. So certainly there's not an entirely united front. So, you know, the long and the short of it is we're in the comment period. Whenever that comment period closes, there's a contemplated effective date for whatever that final rule may or may not look like. I mean, the comment period could get kicked out again. It could close, and then 60 days after that, we would have a proposed rule that would come into effect, and then employers would have 180 days after publication of that final rule to do the things that Jared was just talking about: rescind all current non-competes, send out notice that not to folks that non-competes are no longer, they're void and unenforceable. And in the meantime, I'm sure nobody in this room wants their organization to be the test case, but certainly we are going to be seeing a lot of litigation over this, you know, the breadth and enforceability of the FTC's rule. And so the long and the short of it is, for all practical purposes, even if there is a final rule at some point in time that has any sort of semblance to what it currently looks like right now, it's going to be the source of heavy litigation, and we won't have a final answer until many years from now, most likely. That being said, it of course would be important to make sure that your business falls into compliance with any proposed rule that actually goes into effect. So I feel like we've had a lot of like, doom and gloom. Is anyone panicked right now? Nervous, uneasy? I mean, certainly we don't need to sound the alarms and like run out of the room. This is really, you know, and I think as lawyers, we tend to be a little bit alarmist because, you know, we've been following the trends. We see what might be coming down the pike, and you know, I don't know, non-compete laws is exciting for Jared and I, and we think it's interesting and fun to just discuss and debate and see either sides of it. But for you all, it has a real practical implication, and, you know, okay, what do we do right now? And I think, you know, the proposed rule is still in its early stages, given the vast departure that this rule would have from, you know, the state of the law in Ohio and in, you know, across 47 other states. You know, we don't need to do a complete 360, but next slide. What we should do now is revisit our restrictive covenants, including the non-solicitation and confidentiality provisions, to ensure that they're tailored to protect your legitimate business interests. What many of us do is, you know, in an effort to make sure that we're covering all of our bases, is we draft a standalone non-compete confidentiality agreement that is broad in that you want to cover every single base and make sure that you haven't left out, no stone unturned. You haven't left out any category, for example, from what's going to be considered confidential and proprietary information. But we know that should the FTC proposed rule as it currently stands, or in some variation or iteration down the line, become a final rule, that we're going to need to be a lot more tailored and careful, and give a little bit more thought to how we're going to craft some of the restrictive covenants that we want that certain groups of our employees to agree to. This is especially a good time to, as I said, get your trade secrets house in order. A confidentiality provision is meant to protect your trade secrets. In Ohio, customer lists, provided that they're under lock and key and they're not available to everyone in your organization, can be considered a trade secret. And sales information, forecasting information, marketing strategies, products that you intend to roll out, those can all potentially fall within the realm of what's defined under Ohio law as a trade secret. And so looking at your confidentiality provision and having specific, of course, you don't want to give away in the confidentiality clause itself what that trade secret information is, but using more specific categories than what I see a lot, which is, employee agrees that he or she will have access to a wide variety of, including but not limited to, confidential, proprietary, trade secret information. And it's a whole lot of protection, but it doesn't really specify what it is that the company is concerned about keeping a trade secret, or keeping proprietary, or keeping confidential. So being more purposeful in defining what those would be.
Is it beneficial to identify patents in it?
Is it beneficial to specifically define I would say if that group of employees or a particular employee is going to have access to intellectual property, that a reference to that intellectual property by category would be appropriate. I mean, I'll have to say patent number, what have you. But yes, to give that employee notice of, okay, you are going to have access to this type of information that we deem is important and confidential, and we wouldn't be giving you access to that information were you not to agree to the terms of this agreement. It's something that I think will be important to keep in mind. Speaking up and filing a comment, if you have something to say, that's certainly something you can do. You might want to work with counsel if you want to file a comment, and make sure that you're not giving away any, just keeping in mind that that information will be public record. But these are all things you can do now. I think right now the mode to be in is evaluation mode. Recent enforcement actions. So the FTC proposed rules not in effect yet, but we are seeing the FTC crack down more. And most recently here in Toledo, we saw OI be the subject of an FTC enforcement action. I think OI had a 1-year ban across a variety of its positions, and it prevented former employees from working. The argument goes from working or being involved in any way throughout the United States with a company that did anything that provided similar products or services to OI. And the FTC didn't like that and went after OI. There's also Prudential Security, which was enforcing non-competes for low wage earning, low skill security guards. And again, the FTC didn't like that. The argument was, where's the proprietary information? Where's the, confidential information that this employee could use to go and compete against you? And so we are seeing, it's all the more reason why now is a good opportunity to take a look at your restrictive covenants, make sure that you're only enforcing them to the categories of employees that actually have access to information that could harm you if it were to get in the hands of a competitor, and be more purposeful in crafting those. Oh, so, I got it. Here we go. I think back in the day, we used to say, we've got a solid non-compete. It covers all of our bases. We don't have to worry about it. And again, we're not telling you to run for the hills or throw out your existing agreements, but to just take a look at them and evaluate them. And here's a couple tips for, how to draft an enforceable non-compete. And I think given the amount of time we have left, I'm not going to go through each one of these individually because we've kind of been discussing them informally here. But I would open up for any questions that folks might have before we get into trade secrets about non-competes, drafting non-competes, or if you're in the position of hiring an individual who's subject to a non-compete, you're trying to, bob and weave through that. Any comments or questions, anecdotes you want to share before we shift
I guess
to trade secrets?
I don't know where to throw this out. So we have a number of clients that used to be members of a local union. And they have something I've never seen before, where they cannot, so it's regarding their retirement money, their cash balance retirement. I have one client in particular, I'll tell a story. He's mid-40s, there's about $500,000 in this retirement plan that he'd love to be able to roll out of there and utilize himself. But the agreement that they have says he can't be employed with the local for 12 months, can't be in the industry anymore within 150 miles, or we keep your money in the plan. And the money in the plan is also, it's poorly managed. He has no control over the dollars. Just curious, obviously, how would this impact unions? And in that specific, because I've got a number like that, if I could unlock that money for this guy, it would open up so many opportunities for our business. Ever heard of anything like that? How would this affect things like that? Any ideas?
The union itself has these
Yeah,
restrictive covenants? You?
I've never seen anything else like.
Yeah, that's certainly unique. I mean, typically unions are not asking their members to sign restrictive covenants. So again, I would be interested to look into it further.
I'll chat with you after.
Sure. Great. What else? Okay. Trade secrets. Okay, under Ohio law and Michigan, so there's the Uniform Trade Secrets Act. Many states adopt it. By and large, Ohio has adopted the Uniform Trade Secrets Act as the Ohio Trade Secrets Act. Similarly, I believe Michigan has the Michigan Uniform Trade Secrets Act, and it defines trade secrets as follows. It has to derive, and so this comes into play when you're talking about confidentiality provisions and what can be considered trade secret and protectable interests. And it needs to meet this definition in order to constitute a trade secret. And even if you don't have a restrictive covenant that has a confidentiality clause to protect your trade secret information, misappropriation of trade secrets is its own standalone cause of action. That if you're looking back and you realize that somebody took your customer lists, for example, and shoot, you didn't have them sign anything, and now they're out there disseminating all this information. What can we do? Well, if your customer list meets the definition of a trade secret, you might have a cause of action anyway. So the trade secret has to derive actual or economic value from both not being generally known or readily ascertainable by proper means, meaning not misappropriation. And then this is where people get stung, employers get stung, being the subject of reasonable efforts to maintain secrecy. So, how do you demonstrate that you've taken reasonable efforts to maintain the secrecy of the information that you're now saying is trade secret? Well, do you have somebody sign a confidentiality clause, for example? Do you have a confidentiality provision in your handbook? Is the information password protected? Is the information limited to only a certain group of employees on a need-to-know basis? Those are all sort of the factors that can help demonstrate that, yes, in fact, we deemed this information trade secret, and we, the employer, took steps to make sure that it was being treated as such throughout our organization. Oh, this one's you.
All right, I apologize for the cough, but of course I got a cold today doing the presentation. So examples of trade secrets, you might be asking, okay, what is a trade secret beyond this technical legal definition? I mean, we all know the classic one is the recipe for Coca-Cola, right? So a unique formula, process, or design that no one else knows about. Client list, as Ann mentioned, or customer list. Excuse me, vendor or supplier list. And even your strategic business plan. So really anything can be a trade secret if it's something that is unique to you that no one else knows and that which you adequately protect. And so as Ian said, the real thing that trips people up is whether you have reasonable efforts to maintain secrecy. You should have a confidentiality agreement in place. You should keep information on a need to know basis anyway. Who really needs to know about this? Is everybody in shipping and receiving need to know how you make the widgets you're shipping out? Probably not. And you obviously have to secure the information from the public. And the important thing about trade secrets, we've thrown around the phrase legitimate business interest a couple of times when talking about covenants not to compete and other restricted covenants. You know, most courts will look at a trade secret as a very legitimate business interest you have to protect. So if you have trade secret information to protect, you're much more likely to obtain enforcement of a restrictive covenant, whether that's a non-solicitation, a non-disclosure, or a covenant not to compete. And most causes of action related to trade secrets will entitle you to injunctive relief, meaning if you lose that trade secret status, that is an immediate irreparable injury that can't be fixed by just giving you money. So no amount of money that a court could award you would replace losing the formula of Coca-Cola for Coca-Cola, right? If somebody else can start making Coca-Cola tomorrow, there's not enough money in the world to make Coca-Cola whole for that, right? And that includes the Federal Defend Trade Secrets Act, which is a special statute that allows you to go right to federal court in certain circumstances to protect trade secrets and allows you extraordinary remedies like civil forfeiture and punitive and exemplary damages. Kind of racing through this because I know we're towards the end. Non-disclosure agreements. Okay, so we talked about that a bit. Why do you have a non-disclosure agreement? Well, most obviously to protect trade secrets and confidential information. It's going to be really difficult to argue that you've made reasonable efforts to protect your trade secret if you don't have a non-disclosure agreement or confidentiality agreement with your employees who know that information. You're going to want them also with customers to the extent they need to know certain trade secret information about your processes, your pricing, or other factors with the relationship. And certainly when you're looking at joint ventures or other potential business partners, it's very common to have a joint mutual non-disclosure agreement if you need to share financial information or product information in order to determine whether you can really work together. So when you're working those out, make sure you're thinking carefully about the information you need to protect, how long you need to protect it, who on each side really needs to know the information, and bargain for and specifically negotiate those in a written agreement. And so what do you mean by non-disclosure? Another place people get tripped up is they worry about the disclosure part, but they forget about use. You know, remember, once you disclose something to someone, they can't unknow it, right? So you could prevent somebody from disclosing that information to a third party, but you need to specifically also bargain for that party's not going to use the information for their own personal purposes. And sometimes people forget that aspect of it, which is, you know, seems fundamental, but it happens more than you think. So like I said, a big mistake is forgetting to protect against that person actually using the information for their own purposes. And the other big mistake is that just having the agreement in place is all you need to do to maintain secrecy. And I'll tell you a quick example of a true horror story. I'm going to change some facts and be vague to protect confidentiality. So we had a couple with a great idea for a niche business, a recreational type business that didn't exist in their market. They went out, did the legwork to identify the specialty vendors and suppliers they would need to set this business up. They figured out the business plan in terms of how much they were going to need to get it started up, you know, what their labor costs would be. They had a whole business plan in place. They went out and acquired real property on which to build the business they wanted to build. And they even went and got a zoning change to allow for the specific type of business they would want in the area that they own this real property. So when they were all ready to go, they just needed some additional capital. So they invited a select group of people that they knew who had money, who might be interested in investing. to come to a meeting like this and make their pitch and see who they can get to invest. And they had everybody sign a non-disclosure agreement beforehand. Well, what happened? One of the attendees said, hey, that's a great idea. I'm going to go steal it. So he left the meeting. He went and bought real property in the same area where the zoning had been changed. He went and tracked down similar vendors or all the same vendors they had, lined up his own investor group, bought a building, and he was open before they were. And they were a little mad, surprisingly. And when they had two big problems. Number one, their non-disclosure agreement only said that he wasn't allowed to disclose the information to third parties. He didn't disclose anything to anybody. He had it all in his head. He didn't tell anybody where he got this idea. The other problem was after the pitch meeting, a couple of the slides they used, they put on a private Facebook page for the people who attended the meeting. Well, okay, the Facebook page is private, but it's still public, right? So they had publicly disclosed certain aspects of it. And then finally, the zoning change was the other thing they complained about. Well, anyone can go on the zoning website and figure out that there's been a zoning change on. So while this guy obviously did something mean and unfair and dirty and underhanded, and he should be ashamed for the rest of his days, he's a pretty smart business guy because he beat him to the punch and he made some money doing it. So, you know, just having some piece of paper saying thou shalt not disclose doesn't do it. You've got to really protect your bases. Don't put stuff on the internet if you want it to be secret, right? And also be a little bit more selective about who you invite to your pitch meeting, I guess, would be the other moral of that story. Non-solicitation agreements is this one?
It is, I think we've kind of beaten the non-solicit, non-compete to death, but if anyone wants to chat through non-solicits, again, I guess the disclaimer, we can't provide legal advice, but certainly with hypotheticals and scenarios, we can, you know, share our thoughts on those sorts of situations. But certainly, I hope what you all take away from today is that yes, on the horizon, there are a lot of restrictions that we might be facing, but that certainly doesn't mean that you can't and that you shouldn't continue to be thoughtful in the way that you're protecting your business. Jared and I are always a resource for that.
And so that's our contact information or email. So feel free to shoot us an email after this if you have any questions. I've got some business cards too, if anyone wants other contact information. And if you have any questions, feel free to grab us after this. Thank you very much.